Good evening, ladies and gentlemen, and welcome to our 9th session of Constitutional Revival. It's hard to believe that we're now up to 9. I remember when we started in the heat of the early summer, and we have made our way through a bunch of the Constitution. I want to say again that I want to thank Joanne Woodard and David Hagar, without whom this never would have been possible, never would have got off the ground. David's company is Beyond Innovative Technologies and Consulting, and he does a great job for us, or else I wouldn't be in your living rooms again this evening. So thank you, David and Joe. Anyone wishing to review the material, if maybe you haven't been able to see every one of the different installments of the Constitution so far, can go to my YouTube channel, Constitutional Revival with Royal Alexander, and keep up and catch up if you have missed any of the different sessions. We begin tonight with the 6th Amendment. This is an exciting Sunday night because, of course, in 2 days we're going to have the elections, of course, including the presidential election, all of which to me does nothing but underscore the importance of what we are doing. Well, we are into the amendments that I describe as the criminal elements, the criminal defense, the criminal rights part of our U.S. Constitution. We did the 5th Amendment, and continuing in that flow, that pattern, we're doing the 6th Amendment tonight. What does the 6th Amendment, what rights does it grant us in the Constitution? And it's several, but they're, to me, very straightforward, but so very important. Let's start with the text, as my law professors used to say. In all criminal prosecutions, the accused shall enjoy the right to, number 1, a speedy and public trial. And I'm going to break these down in a minute. But number 1 is the accused, the defendant, shall enjoy the right to a speedy and public trial. Number 2, the trial will be conducted by an impartial jury of the state and district wherein the crime was committed, allegedly. That speaks to venue. In other words, it's supposed to be a jury of our peers, and I'm going to address what that means in a minute. But number 2 is an impartial jury. That means people who they're not partial in any way, they're impartial, meaning they can keep an open mind, they don't know any of the attorneys, they're not going to prejudge the case. An impartial jury is probably the closest thing we have to a guarantee of real justice in this country. All right, an impartial jury of the state and district, people from that area. 3, which district shall have been ascertained by law? And mostly what they're talking about there is venue. Where does the defendant live? Where was the crime committed? Who has jurisdiction? That's what they mean by the district, which shall have been previously decided by law. Number 4, and to be informed of the nature and the cause of the accusation. In the 5th Amendment, we talked about the indictment or presentment. Someone who's accused of a crime has to know exactly what they're being accused of. And again, we see that referred to clearly again in the 4th part of the 6th Amendment. To be informed of the nature and the cause of the accusation. Specifically, you got to specifically tell the person you're accusing what law, what infraction, what violation, what illegality they've committed, specifically. Number 5, to be confronted with the witnesses against them. That's hugely important. We don't deal in hearsay. And I'm going to speak more about that in a minute. People will commonly say, oh, that's just hearsay. It always makes me chuckle because hearsay is a particular term of art. But in a way, when people say it in the common parlance, in the vernacular, what they're saying is kind of synonymous with what the term of art hearsay means, but not exactly. What hearsay means is something that someone has declared outside of a courtroom. The only reliable evidence, really, is what's said and determined, said live under oath in a courtroom. So we have a right to be confronted with the witnesses who are accusing us of a crime. Not what someone said over in the next city or in the next state. What are the people saying? They have to be right here in court, under cross-examination, under oath, saying that. I have a right to directly confront and cross-examine those people. They have to be in court in front of me. Now, there's certain exceptions to it, but that's the rule. To be confronted, the accused has a right to be confronted with the witnesses against him. The next is to have compulsory process for obtaining witnesses. A lot of people, if they weren't forced by a subpoena to be in court, they'd say, oh, I don't feel like going to court. I don't want to be a witness. In fact, I don't want to serve on a jury. But when you get that summons in the mail for jury duty, and definitely when you get a subpoena telling you to come to court, if you don't, then a warrant's going to issue for your arrest and you can be arrested. So it's a good idea to come to court when a subpoena comes or when a summons comes in the mail for jury duty. But compulsory process means if someone is going to testify on my behalf, I can compel them to come to court, be under oath, and testify about what they know. That helps my case. That's exculpatory. We've talked about what exculpatory means tend to show that I am not guilty. Anyway, if you didn't have compulsory process, in other words, if you couldn't subpoena people, they wouldn't come and testify in a way that helps me as the defendant. So that's the next one. And the second to last one is to have the assistance of counsel. What that means is effective assistance of counsel for my defense. These are criminal matters. It's different for civil matters, but I'm going to run through them again. A speedy and public trial. If I'm accused of a crime, the Sixth Amendment mandates that I have the right to a speedy and public trial, an impartial jury of the state and the district where I'm supposedly committed the crime, where it's previously ascertained by law, meaning venue. 4, to be informed of the nature and cause of the indictment, of what I'm being accused of. 5, to be confronted right in court with the witnesses against me, and to use compulsory process to have witnesses come for me who will testify on my behalf. And lastly, to have the assistance of counsel for my defense. All right, what does it mean? Let's look at it. What is the right to a jury trial? Hugely important to hear 6 or 12 impartial jurors hear your case. Very, very important. Critically important. Why? Because that's the best chance for real justice to be done. Why? In a criminal case, the government prosecutes or charges a defendant with a violation of a criminal law and begins the proceedings, the bail hearing, whether or not I will receive bail, and if so, what my bond will be, or whether I'll be remanded and held in custody the whole time. So that's the first thing, bail hearing, an arraignment, which means I plead guilty or not guilty, and thirdly, the trial. Those are the kind of things that start going, that begin at the time an indictment comes down. Those things have to be used to prove the charge beyond a reasonable doubt. When I'm accused, whatever I'm accused of, the state, not me, the burden is not on the defendant. The burden is on the state, say the state of Louisiana, to prove that I was using illegal drugs, that I was selling illegal drugs, that I stole money, that I counterfeited money. The burden is on the state. It's on the government to prove beyond a reasonable doubt that I did those things. All right. The Sixth Amendment provides many protections, as we just went over, and rights, protections and rights to someone accused. One, again, is the right to an impartial jury. Independent people from this area. I live in Shreveport, Louisiana. That means people in the city of Shreveport, in Caddo Parish, or out in the parishes nearby, depending on how big the area goes. In federal court, it can be the entire Western District of Louisiana. but they have to be people who generally live near where I live. And that's what's supposed to be a jury of my peers. So people in the community nearby, independent people who are willing to decide the case based only on the evidence, not on something they read in the news, not on something they saw on TV, not on something they researched on the internet, on the evidence that's admitted at trial. That's what an impartial jury means. They can't go do independent research if you're on that jury. You're limited to knowing what the judge says may come into evidence. Okay? So people from the surrounding evidence from the surrounding community based just on the evidence that comes in at the trial. In some cases, keep in mind, you know this, where there has been a ton of press, a lot of negative press maybe a very high profile murder of someone prominent in the community, maybe by someone's spouse. It's in the news and in the news and in the news. Well, a lot of people who may end up in that jury are seeing the news. And after a while, before they're ever called to possibly be part of the jury, they begin to develop perceptions about who they think may be guilty, who may be innocent, who did it. Well, in that case, the defense attorney, if I were, and I do criminal defense sometimes, if I were the attorney, I would make a motion for a change of venue. I would want to move the trial out of Shreveport, maybe to Bossier, heck, maybe to Lafayette, Louisiana, maybe to Baton Rouge, Louisiana, where there has not been so much news, maybe no news about this case, where it's easier to find 12 impartial jurors who haven't been watching this story on the nightly news and who haven't formed opinions based on their own observations of the news, radio, TV, the internet, what have you. So move it to another place and choose 12 people from that place who are impartial to hear the case based only on the evidence. So change of venue is very important. I know you've heard of it through movies and other things. Now, when choosing a jury, it's a very important process. It's called voir dire. It's a word which just means picking a jury. Both prosecutors and defense attorneys participate in the process, more so in state court. In federal courts, the judge typically does the voir dire. The judge usually goes through and picks the jury. That's just how it's done in federal court. But in state court, the prosecutors and the defense attorneys have a much more active role in picking the jury. Again, usually 12 out of maybe 100 people who get called for jury duty. And you whittle it down and you whittle it down and you whittle it down till you usually have 12 people and 2 alternates in case maybe one of the jurors gets struck in the middle of the trial and an alternate fills in, or for something, maybe gets sick, something else. 2 alternates, 12 jurors, 14 people are chosen, usually out of about 100 who start out in the jury pool. It gets whittled down to 12 active, 12 jurors and 2 additional ones who serve as alternates if need be. Now, some of the objections that both the prosecutors can make, again, you got to work your way through all the people in that jury pool to see if any of them know me, if any of them know the prosecutor, if any of them know the judge. Usually we're going to strike them. You want people who don't have any connection to anybody. If someone says something to you like, you know, anytime they get indicted, I believe someone ought to fry. Well, just because you're indicted doesn't mean you're guilty. If I were the defense attorney, I would strike that juror immediately for cause. Just because from hearing them say, oh no, anytime someone gets indicted, that's enough for me. I think we ought to fry them. I think they ought to go to jail. The prosecutor may like that, but I do not like that at all, because they're already deciding just because my client was indicted that they're guilty. And that's totally wrong. We're presumed innocent until we're proven guilty beyond a reasonable doubt. We went over that before, so don't forget that. So the prosecution and the defense attorneys go through and they have certain strikes for cause. A cause, again, is if the juror has said or done something that shows he or she cannot be fair. So I would strike that first juror for cause when he said, I think we ought to fry them when they've merely been indicted, accused. That's totally wrong. If that's how that juror thinks, I don't want them on my jury if I'm the defense attorney. Again, the prosecution probably would like them to stay on there. Other kinds of strikes are preemptory exceptions. That doesn't have to be for any particular reason at all, except it cannot be preemptory exceptions, preemptory strikes, they call them. You strike a juror for cause, you strike a juror based upon a preemptory exception, a preemptory strike, I should say. And for a preemptory strike is basically because you don't like the color of their hair. You don't like the way they're sitting there. You don't like the way they're scowling in the jury box. They look angry or mad, or they look totally out to lunch, like they're not listening at all. Body language. But you cannot just strike them a preemptory strike because, for example, they're a black juror, and you can't strike just because it's a male or female. There has to be some other ground because those have been deemed essentially unconstitutional. You can't strike people off a jury just because of race or gender. But other than that, there are many reasons. Somebody comes in smelling like alcohol in the morning. I'm telling you, when you've seen it long enough, people, you know, they get said, well, if I got to show up, I'm going to show up, but I've been drinking all night. I'm going in there. Well, probably if someone can't stay awake in the jury box because they're drunk, they're probably not going to be the best juror. Those can be struck for preemptory challenge. That's a preemptory challenge. They can be struck from the jury based upon that preemptory challenge. So you work your way through. Ladies and gentlemen, do you know me? Do you know the prosecutor? Do you know the judge? Can you, other than most of you don't want to be here anyway, and you know, a lot of people just don't want to be there. Putting that aside, you've been compelled to be here. This is part of our, well, it's part of our constitutional republic, our representative democracy, and our judicial system. We can't function if we don't have 12 people who will put aside any bias, any prejudices they have, and hear the evidence and only the evidence presented in court. You work your way through it. Prosecutor strikes. Oh no, you know, he'll say, I believe it's good. I promise you, the prosecutors that I know, if a juror says, oh no, I think only God can judge, I promise you, the prosecutors that I know are striking that juror immediately, either for cause or maybe if they didn't even need to make that statement. Because if they say only God can judge, that means they'll never be able in their heart and mind to arrive at a conclusion of guilt because only God can determine guilt. Well, if that's the reason, I promise you the prosecutors I know are going to strike them quickly from the jury. You get to go home. Thank you. You're excused, ma'am, if you think that only God can judge. Because our jury system is based on being able to render a verdict if you have reliable, competent evidence and 12 people deciding who don't have a bias. They don't like or dislike anyone. They don't know anyone here. They're just showing up because they're compelled to. You go through it, and sometimes it takes hours to go through voir dire, working down from 100 people to 12 and then 2 alternates. But it's critically important. Again, the right to trial by jury is so important in criminal matters. It's important, period. But right now we're focusing on criminal matters. So you keep going through the voir dire process. Now you've picked your jury. What else does the Sixth Amendment allow? You're allowed a speedy trial. You're allowed a public trial. But right now we're going to talk about a speedy trial. You can't leave a defendant languishing in jail for weeks and months and years. You can't. Why? Because it violates the presumption of innocence. Because until they're convicted beyond a reasonable doubt, they're innocent. So while you're holding them in jail, again, if they're a flight risk, that's another matter entirely. That way they don't have bail, no bond gets posted, and they don't get to be outside of jail waiting trial. If a judge just looks and says, this is a flight risk, and I know you've seen it on movies, they sometimes take their passport. But if you have a lot of ties to the community, a lot of life, family, everything keeps you tied locally, it's more likely that bail will be set, a bond will be posted, and you'll be able to remain out of jail until trial. Whatever the case may be, even if you're in jail, if the judge says you're a flight risk, you're remanded to jail, you still have a right to a speedy trial. Wow. Why? Because while you're stuck in jail, you're presumed innocent the whole time. Therefore, you're being incarcerated without due process of law. You haven't been deemed guilty beyond a reasonable doubt. That's why you have to have a speedy trial. Now, what amounts to a speedy trial kind of depends on a judge's docket. Speedy, it's a term, I mean, it's a term of art, but it's a variable thing. Speedy doesn't mean 1 week or 2 weeks. Sometimes it may mean 2 months. Sometimes it may mean 4 months. But it's supposed to be fairly rapidly, because again, in a criminal matter, you're holding someone in jail, incarcerated, who has not been proven guilty beyond a reasonable doubt, and that's an illegal incarceration. So it's also crucial to assuring that the defendant receives a fair trial. Why? Because we all know this, as time passes, our memories fade. What we thought, last week we remember, yesterday we remember something very clearly. Next week, we'll still remember it pretty clearly, but in a month from now, maybe not as clearly. In 2 months from now, certainly not as clearly. And in time, our memories begin to fade. So not only that, but witnesses, they die. Witnesses die. Witnesses move out of state. Witnesses move out of the country. So their memories fade. Physical evidence can be lost also over time. It can be mishandled. So all of that is addressed by a speedy trial. That's why there's great pressure in a criminal matter. Again, civil cases, civil jury trials can get bumped and bumped and bumped for years. Bad car accidents, plant explosions, all of those things are civil matters. Criminal matters, the Constitution requires that, relatively speaking, the criminal trial takes place in a speedy fashion. Okay, that's the right to a speedy trial. You also have the right to a speedy and public trial. Remember, I said public is going to matter in a few minutes. You just heard about how important the right to a speedy trial is. How about the right to a public trial? Well, the right to a public trial serves the interests of both the criminal defendant, and the public. Why? Why does it serve the interest of both? I'll tell you why. Because defendants are protected from secret proceedings that might encourage abuse of the justice system. In other countries, remember, we left England, we left Great Britain because sometimes secret trials, it's called the Star Chamber. No one would ever know, who's my judge? What am I being tried for? You get jerked into this dark place, some candles burning, and you're told you are being accused of this. You have no one there to defend you. A few people say, I saw him doing this. Maybe there's no evidence. You're whisked away to jail for the rest of your life, or you may have your head cut off. You may be hanged. The Star Chamber. That's not justice. That's not due process of law. So when it's out in the open, defendants are protected from a secret proceeding that might encourage abuse of the justice system, like some arrangement like the Star Chamber would. No one knows what's going on in the Star Chamber. All your rights could be stripped in a situation like that. Also, the public is kept informed through the media. The public is kept informed about how the criminal justice system works and how it's working, for example, in this high-profile murder case, like a prominent doctor's wife ends up murdered at their home. He's gone. Maybe he had something to do with it. It's in the news every day. Maybe you make a motion for a change of venue. Maybe you don't. Maybe the judge says, no, I'm not granting the change of venue because it's newsworthy, but there's lots of things that are newsworthy. And that's why we're going to go through the jury selection process, voir dire. So whatever the case may be, the public is watching. And with the public watching, that tends, again, the greatest disinfectant is sunlight, transparency. The greatest disinfectant is sunlight. Let the public watch the trial too. And the more salacious, the more interesting, the more gripping, bloody, whatever, probably the public tends to tune in more. So the public is kept informed about how it works. Like most constitutional protections, however, the right to a public trial is not absolute. Sometimes a criminal defendant may voluntarily waive their right to a trial in order to take a plea agreement. They don't want to take the risk of going to trial because they think the plea I may be offered, the plea bargain, the plea offer may be better to take if I plead guilty than what the jury may do at trial. That's very important, though, that if a judge is going to accept a guilty plea, usually to a lesser offense, which is the whole motivation for someone accused of a crime to take a plea in the first place, because they're going to get what's a lighter sentence than what the law may allow if they are convicted. If that's the case, a judge has to go through and be very certain the defendant understands all of these rights, that they get to have a witness subpoenaed on their behalf, that they get to have evidence introduced on their behalf, that they get to have a jury of their peers that's impartial hear their case, that they get to confront and cross-examine witnesses, if I didn't already say it just now. All of those things, a judge has to go through every one and say, okay, you're accepting this plea, which you think will be less. You're going to be given 10 years in jail, because if you go to trial and are convicted of second-degree murder, you could be in jail for twice as long, 20 years. Well, you don't know what the jury is going to do. The prosecutor also doesn't know what the jury is going to do. The defense attorney certainly doesn't know what the jury is going to do. So everyone says, well, the prosecutor says, well, I'd like to put him in jail for 20 years, but I'm not sure I can convince the jury. I'd rather get him to agree to go to jail for at least 10 years. 10 is better than nothing. I'd rather have him in jail for 20 years, but 10 years, if he agrees to a plea agreement, is better than nothing. Because what if the jury acquits him? If he's acquitted, he's not going to do any time. Here, if I offer him a plea agreement, he may take 10 years. At least I know he's going to be in jail 10 years. The defense attorney, on the other hand, could say, well, client, defendant, you're accused of, say, manslaughter. You were in a heat of passion, or second-degree murder, whatever the case may be. I think I'm a pretty good attorney, but I don't know for a fact what a jury may believe. I think we have good evidence. The state has to prove your guilt beyond a reasonable doubt, which is a huge standard of proof. Again, it's not like a preponderance of evidence in a civil case. You rear end somebody driving down the road. The plaintiff just has to prove beyond, a preponderance, 51-49, 51% to 49%. All they have to prove is 51%. You rear-ended me, but when you rear-ended me in my car, your car rear-ended my car, you caused whiplash, you made me have to have a back surgery. All you have to prove is by a simple preponderance of evidence. In a criminal matter, it's proof beyond a reasonable doubt, which I consider on the spectrum to be about 80 or 85% certainty. It's proof beyond a reasonable doubt. You can't even have a reasonable doubt. You got to be certain even beyond that the defendant committed a crime. It's a heavy burden, and it's supposed to be a heavy burden because in a criminal matter, you're about to deprive someone of life if they're going to get the death penalty, and certainly their liberty, their freedom, if they go to jail for a long time. That's why proof beyond a reasonable doubt is such a heavy standard that the state has to prove. Your criminal defense attorney just gets to play defense the whole time. The state has to be on offense. The state carries the burden in a criminal matter of proof beyond a reasonable doubt. So that is why, speedy trial, public trial, but you can agree to a plea agreement. And then the judge, to accept your plea, a judge has to go through a very elaborate list in court saying to the defendant with their attorney, say, I'm Mr. Davidson, who is accused of a crime. Mr. Davidson, you are accepting a plea today. Is that right? That's right. And for that purpose, you're pleading guilty. That's right. You're pleading guilty to this. That's right. And in return, you're going to get a 10-year sentence in jail rather than the 20 years that a jury could impose upon you. That's right. Okay. Before I accept your guilty plea, I have to know that your guilty plea is knowingly made. Knowingly made. You, the defendant, Mr. Davidson, not your attorney. Your attorney hopefully has explained it to you. But you, Mr. Davidson, need to understand, by waiving your right to trial, an impartial jury, and all those other things I've said, you or waiving the right to confront and cross-examine witnesses, to have evidence introduced on your behalf, to have witnesses compelled to testify on your behalf, to have all those other things that I mentioned, that a speedy trial, an attorney, a competent attorney, if you can't afford one, to be appointed to represent you. You know that whole thing. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided for you. You know that whole thing. So these are very powerful protections. Plus, you don't have to testify against yourself at trial. Remember, we went over that in the Fifth Amendment. You don't have to testify against yourself. That's when you get to plead the Fifth Amendment. And when you plead the Fifth, the fact that you pleaded the Fifth cannot be used against you in trial. They can't even mention it. The prosecutor would like to say, you know what, he's so guilty, he won't even testify. I know a lot of prosecutors who would like to be able to say that. The moment they say that, I, as the defense attorney, am going to move for a mistrial, because they cannot say that. They cannot use someone's decision not to testify on their own behalf at trial as some essentially strike against them. Cannot do it. That's immediate grounds for mistrial of a case. So you get all those rights. As I said, you get to be right to be informed specifically of the crime you're being charged with, specifically. And if it's not clear, your attorney, the criminal defense attorney, can object, and the judge will tell the prosecutor, you need to rework your indictment and make it very clear, because right now it's not clear to the defense attorney what you're accusing the defendant of, what you're accusing his client of. It's got to be very clear. Okay. What else? Confront, cross-examine. Sometimes, for example, in a child abuse case, say a child sexual abuse case, the court won't require the child to actually be in the courtroom looking at the accused, the defendant, because courts have said that's traumatic for a child to have to do that. So they'll let the child testify by camera from the judge's courtroom. So they don't have to look at the defendant. They don't have to look at the whole crowd, but the jury can certainly see on camera the child testifying. And all that's in there is usually a court reporter, the judge, maybe both the defense and the prosecuting attorneys, but that's all. So the child doesn't have to look at the person who possibly sexually abused them or physically abused them. But other than that, there's a strong right to personally, within 10 feet of each other usually, in court, your attorney, like someone like me, cross-examining the witness, because cross-examination, it's a powerful tool, because you get to lead the witness on cross-examination. You get to treat it as a hostile witness. Someone testifying against my client is the witness of the prosecution. They're not my witness. They're testifying against my client. And brother, when they're testifying against my client, they're getting cross-examined. They better know things specifically. They better know them tight. They better have a clear memory. They better be saying the same thing now that they said in the police report. They better have very good recollection, because we're going through all of it. And I'm going to do everything I can to undermine their testimony, because I think what they're saying, well, they're trying to convict my client. And that's why they're going to endure a cross-examination by me. In the same way, a witness that I've called to testify on behalf of my client, I promise you, that prosecutor is going to cross-examine that person just as hard as I do their witness. That's cross-examination. Cross-examination is one of the most important tools in trial. It's a very important skill to have. And truly, on cross-examination, you're only supposed to do harm. You know that old expression, physician first, do no harm? Well, it's just the opposite in the law. That's in medicine. Physician first, do no harm. In the law, on cross-examination at trial, you better only do harm, or you shouldn't even cross-examine. And that's hard a lot of times. But if you can't damage the witness you're about to cross-examine, then you shouldn't cross-examine them. It's not for someone's ego. I've seen some big-time criminal defense attorneys, they just can't resist getting up there and cross-examining. But if you do cross-examine, it needs to be very precise, because what you're doing is moving sometimes from the sob story of the prosecution's witness to your, okay, I have no further questions, the prosecution says to the judge, for this witness. Defense counsel, your witness. Then it's my turn. I'm not going over anything. If it's done appropriately, cross-examination, it's a start turn in trial. You can feel the air come out of the courtroom sometimes. All of a sudden, they've been crying. I've been so sorry. This happened and that happened. Because when I come, the first shot is, bam. Are you lying today? Are you lying? Are you lying today? It's going to be something like that. You've said these kind of things before. You've had multiple affairs. You've stolen money before. It's going to be all the sympathy from the jury looking at them to my first question, pop. And if it's not a pop, then I'm not cross-examining. I want to snap the jury out of it. I want to return them to the fact that this person is not a special person. They're not a good person. And by the time I'm finished, and it may be a lengthy period or a short period, I want the jury to think that that witness of the prosecution's testifying against my client has less credibility than they did at the beginning. So I'm going really right for blood. I'm going right for the jugular vein. I'm going to draw blood because their testimony is going to be used possibly by the jury to convict my client of something he or she may not have done. And if they're going to be successful doing it, they better be ready for the hammer that's coming. But it's not anger. It's not, an attorney always has to maintain their composure, because if you lose your composure, then you're going to be less effective. So you got to be right on the edge of the top of your skills, but you have to maintain your composure, because the idea is to get them to lose their composure, because then the jury is going to give them their testimony less credibility. And maybe if it's given less credibility over the course of the trial, they're going to be less likely to find my client guilty. That's why I say the crucible of cross-examination. There's nothing else like it. Opening statements, both sides get their opening statements. Both sides get closing statements, and they're very important also. Both sides get direct testimony of their own witnesses. They get their direct testimony of their witness. I get my direct testimony of mine, but we get to cross-examine each other's witnesses. Therefore, my witness that I've called is considered a hostile witness for the prosecution, and they get to cross-examine them and lead them. You did this, didn't you? You did this, didn't you? You used to do this, didn't you? You've lied before, didn't you? You've cheated before, didn't you? In fact, this isn't the first affair you've had, is it? That's not the first time you drank and drove. You did it many times before. And you gotta damage credibility. They'll be trying to damage my witnesses, the prosecution will, and I will certainly be trying to damage the credibility of their witnesses. It's the crucible. You know what a crucible is? It's where metal gets forged, melted, and forged into something else. It's very hot in there. That's why they call it the crucible of cross-examination. It's critically important to do harm. I know that sounds counterintuitive and kind of harsh, but a trial is harsh. A criminal trial is an adversarial proceeding. And I know you know what it means to have an adversary. That's an opponent. I know prosecutors who would just as soon hear the word guilty more than they hear any other word. It gives them more joy than, well, I'm not going to mention the other pleasures in life, but I know some prosecutors who find more joy in hearing the word guilty than just about any other of life's pleasures. And I mean any other of life's pleasures. And I know a lot of them who are zealous and who can be overzealous. I'm not saying there's not some great prosecutors, but they would say the same thing about me. Royal, no matter what I showed you, you wouldn't think your client's guilty. That's not true. But if I'm hired to defend someone, they have a right to be represented. And I'm going to do it to the very best of my ability. And everything they say against my client, I'm going to smash it as hard as I can. I'm going to undermine it as best I can. I'm going to put the most doubt in these witnesses' minds as I possibly can, so I can undermine their credibility, so the jury won't believe those things they're saying under oath about my client. I want to say, well, maybe you confused him with someone else that night. Maybe when you looked across the room, Had you been drinking? Maybe you were drunk. Maybe you were tired. Maybe your eyes were playing tricks on you. You know, maybe there's 100 things you think of in a trial that to undermine what they're saying is, oh no, I saw your client, the last person in there where they found that woman murdered. And I'm like, brother, we are going over that. We're going over that and over that. And you better be straight, because it's going to be questions, well done cross-examination questions. Everyone, nothing is extraneous. It's got to be like weaving, like the way you'd be knitting. Everything has a purpose. Everything is supposed to slash. It's death by 1,000 cuts. Slash. Doubt, 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 doubt. Maybe tiny, but over the course of a trial, you create doubt, create doubt, create doubt. While there, the prosecution, I promise you, is doing everything it can to smash my witnesses as hard as possible, doing the same thing, trying to undermine my witnesses so that the jury will believe the prosecution's case and convict my client. That's why I have extrapolated all of this for you, and I have gone into this great detail because I want you to understand these are not just theories and words you hear. It all matters. It all matters. Both sides. I know I'm a zealous advocate because I'm defending my client. And I promise you, the prosecutor is a zealous advocate. The prosecutor wants to act like we always wear the white hat. No, they don't. I'm not saying there aren't some very fine prosecutors, but I'm telling you, I've seen prosecutors who haven't turned over evidence, exculpatory evidence. Remember, we talked about that earlier in the course? Exculpatory evidence. That's the evidence which would tend to exonerate my client. They don't turn it over because they know it might tend to exonerate my client, like DNA evidence. Well, a lot of bad convictions happen because the prosecutor doesn't turn over evidence that's exculpatory to me, like the law requires them to. Exculpatory evidence has to be turned over to the defendant. And sometimes they don't. Again, I'm not bashing prosecutors. What I'm saying is a trial, especially a criminal trial, is a throwdown. It is a throwdown. It is a fight. And the judge is supposed to be the referee, and the jury, after you've gone through all that voir dire, after you've whittled it down from 100 people to 12 with 2 alternates, you've gone through and said everything. Can you judge this case? No, only God can judge. Bye-bye. You kept people who said, the drunk juror's got to be gone. The one who says merely an indictment, we should fry them or put them in jail, they're gone. Do you know me? Got to go. Do you know the prosecutor? Got to go. Do you know the judge? Got to go. Those strikes, peremptory or for cause strikes. You strike a juror from the panel, from the jury. All that. You go, it's and then you have a right to assistance of counsel. And what that means is to effective assistance of counsel. Now, when I say you have a right to a counsel, that's all that you hear in those Miranda warnings. If you cannot not afford an attorney will be, I cannot believe how fast the time goes. If you cannot afford an attorney, one will be appointed for you. Well, now you've had one appointed. I've been appointed to pro bono cases. You know, if it's a real criminal trial, it's going to take a lot of time, and a judge has the power to say, Royal, you're not going to be paid for this, but the court is ordering you to represent this person in this criminal matter. But typically what judges do is they go down the list of attorneys, and I always kid my law partners, especially one whose last name is Smith, Craig Smith, my law partner. I always say, it seems like they never work down the alphabet, because I'll be appointed to a case that's going to take a lot of time, pro bono, which means I'm not going to be paid for it. I always want to see them work their way down alphabetically to get all the other attorneys, and it seems like they never get down to the S's, because Craig Smith seems like he doesn't get appointed to, and then they come back around to Royal. We're back up at the A's again. How did we get back to Alexander? When did we go through the S's? When did we go through the whole rest of the alphabet? But if a judge appoints you, then you take the case and you defend them. Now again, I can promise you this: in a major felony case, major felony, criminal trial, if your client is convicted, they're going to seek what's called post-conviction relief. And one of the grounds, no matter what, how well a job you did, is going to be appeals court on my appeal. And when I'm seeking post-conviction relief, meaning I've been convicted and now I'm appealing my conviction, post-conviction relief, one of the grounds is going to be I had ineffective assistance of counsel. Every time. Of course, if you're a defendant and you've been convicted, you want to throw everything you can at the appeals court to say, this was done wrongly, the jury did not receive correct jury instructions, the wrong evidence came in, or evidence that was precluded from coming in that the judge didn't let come in, should have been allowed in. If you're going to be in jail for 20 years, you're going to throw everything. So maybe the appeals court will find one thing wrong and reverse it and make them give you another trial. So, but if all effective assistance of counsel doesn't mean that you're going to get to win. It means that you have an attorney who was competent. So again, that's the Sixth Amendment. Again, let me run through it quickly. You have a right to a speedy and public trial. You have a right to an impartial jury in the state or city where you're from, a jury of your peers. And we know that by going through that lengthy process of voir dire, picking the jury, 100 down to 12 with 2 alternates, striking for prejudices, biases, do you know me, do you know them, all that stuff. Impartial jury. In the area you're from, venue. That's what we're talking about, venue. To be confronted with witnesses against them. They got to be there, except in a small exception, like for a child that's been sexually or physically abused, they may be able to testify in the judge's chambers, even though the jury's still watching, the criminal defendant is still watching. I would probably be in the judge's chamber. But they may not force a child to be on the witness stand literally in court, so where they have to look at the criminal defendant, but they can be in the courtroom. Other than that, you get to confront and cross-examine them. Doesn't matter what somebody said down the street. That's hearsay. It's got to be said in the courtroom, because if it's said against my client, we're going through cross-examination, as I've described to you. To be confronted, to have compulsory process. My friend can say, oh no, Royal's client was with me that night. We were drinking beer at the time that woman was murdered. Oh yeah, but I don't really want to try. I don't want to testify. I don't really like going to trial. Here comes a subpoena, brother. You're coming to trial. The court has the power to force you to come testify. And if you don't, you're going to go sit in the pokey till you're willing to testify. That's compulsory process. You have something to testify that could acquit my client, and you don't want to come because you don't like being in front of juries or you don't like court. Sorry, you're coming. That's what a subpoena does. It compels you to come. And then to have effective assistance of counsel. It doesn't mean you're going to win your case. It means you have a competent attorney. Okay. I cannot believe I only have 12 minutes left. I meant to go further, but I wanted you to understand those are very important rights. Those are very important rights that we have in criminal matters afforded by the Sixth Amendment. Okay. Now let me bounce to the Seventh Amendment because it's a short one and it's important. It's a brief one. What it says is, in suits at common law where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any other court of the United States than according to the rules of the common law. Now, I know that's kind of convoluted. Let me tell you what it means. This is important. The Seventh Amendment of the U.S. Constitution extends the right to a jury trial to federal civil cases, such as car accidents, disputes between corporations for things like breach of contract, discrimination, or employment disputes, things like that. But again, these are civil cases in federal court, okay? Federal courts are different from state courts. Keep in mind, they are 2 different court systems, 2 different judicial systems, the federal and the state. They're equally powerful because we exist in a system of, our Constitution creates a system of co-federalism. But what happens in those 2 judicial bodies, judicial forums, is different. I'm talking about the Seventh Amendment in federal civil cases. We've been talking about criminal cases in the First Amendment, in the Sixth Amendment. But now the Seventh Amendment allows in federal civil cases, again, such as car accidents. But again, you're going to have those things, that you have to meet to be in federal court in the first place. We talked about that in the beginning. Federal question jurisdiction or diversity jurisdiction. And I don't have time to go back over them right now. But you have to have a right to be in federal court in the first place. That's already understood. But you're in federal court now on cases such as car accidents, disputes between corporations for breach of contract, or things like discrimination. All those civil rights, federal civil rights laws, obviously would grant you the ability to be in federal court. Well, you're entitled to a jury in those federal civil cases. That's not true in state court. It's not necessarily true, I should say, in state court. It's guaranteed in the 7th Amendment in federal civil courts, but it's not guaranteed in state civil courts. So that's the important thing about the 7th Amendment. We're talking about a jury trial again, but this is for federal civil matters. In the 6th Amendment, we were talking about criminal matters, and criminal matters are just far-reaching. Those protections are all over the place. Here, the 7th Amendment is just allowing them in federal courts in civil matters. Okay, so that's a distinction. Now, I have 9 minutes. We're gonna make a run at the 8th Amendment. Okay, the text of the 8th Amendment is also simple. The text says excessive bail. Remember, we talked about bail. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's all the 8th Amendment says. The text of the 8th Amendment is this, again, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Okay. No excessive bail. What does that mean? The first portion of the 8th Amendment concerns bail, the money paid by defendants in a criminal case in exchange for his or her release from jail. Keep in mind, as I said a minute ago, bail doesn't have to be granted if a judge thinks, oh no, this is a flight risk. I'm going to remand them. But that's why you have to have a speedy trial, because you can't leave someone accused of a crime, not convicted, accused of a crime, sitting in jail indefinitely. That's why we have the right to a speedy trial that we went over in the 6th Amendment. But here, no excessive bail. The money paid by the defendant in a criminal case in exchange for his or her release from jail before trial. Bail gets set, you post a bond against the bail, and you get to be out until your trial date comes. Bail is returned to the defendant, by the way, the bond money, when he or she appears at trial, but it's forfeited if he or she does not appear. In this way, bail provides an incentive for a defendant to show up at trial. However, I can tell you, just imagine this. If you're accused of murder and let's just say your bail is set at $1 million, your bond is posted at $100,000. So if you pay $100,000, you get to be out. Or if your bail is set as $2 million and 10% of that is $200,000. If you're convicted of murder and you think there's a very good chance that you're going to jail, I'm just telling you this happens. I would certainly never advise my client. If the Louisiana State Bar Association is listening, I'm certainly not advising my clients to do anything illegal. But I'm telling you, it happens. $2 million bail. The portion of that you have to pay on bond is $200,000. You pay that $200,000, you're out of jail. And if you think you're going to be convicted, a lot of people flee the country. And they go frequently to a jurisdiction, to another country that maybe doesn't have an extradition treaty with the United States. So there's no way the United States could extradite you from that country back here to face trial. Now, you're not supposed to do that. You're supposed to stay and face charges. But if a judge thinks that's likely to happen, he can deny bail altogether and remand you to be incarcerated until trial. And that happens a lot too. So anyway, that's excessive bail. But other than being remanded because you're a flight risk, bail cannot be so excessive that a normal person, that only a wealthy person could pay it. A normal person should be able to have bail posted. They post a bond against the bail, and then they get to be free until their trial. There's also the prohibition against cruel and unusual punishment. You've heard that. Now, cruel and unusual punishment used to mean like torture, being burned at the stake, crucifixion. At one time, I mean, we've come through some pretty barbaric things, and our Constitution was put in place to prevent some of those things. 5 minutes ago, I may go a little over, ladies and gentlemen, the prohibition against cruel and unusual punishment. This is the far better known part of the Eighth Amendment. I know you've heard that sentence, cruel and unusual punishment. Although, and again, it was intended originally to prevent things like torture, you know, stretching you on the rack like they did, stretch your arms and legs out harder and harder and harder to punish you after you've been convicted, or maybe even to get a confession out of you. Today, that would be a coerced confession and it couldn't come in, and crucifixion as well. You know, all those things were originally the reason for the prohibition of cruel and unusual punishment. But it's been broadened over the years. That term, cruel and unusual punishment, has been broadened over the years in the Eighth Amendment to also be used against punishments that are grossly disproportionate to, meaning much too harsh for a particular crime. For example, except for a brief period I think it was the 1700s, if I remember correctly, except for that period, the death penalty has not been, and I'm not addressing the moral considerations of the death penalty. I'm just saying, as a matter of law, as a matter of constitutional law, the death penalty has not been considered by the U.S. Supreme Court to be cruel and unusual punishment. Itself, the act of imposing the death penalty, meaning if done appropriately, killing someone under those circumstances has not been considered cruel and unusual punishment. You can imagine many people, many scholars, many people disagree with that. In fact, you know, churches, a lot of churches like the Catholic Church, I'm a Catholic, it will not, it sees a prohibition on the death penalty, will not grant a legal authority or a moral authority to the death penalty. It's absolutely opposed to the death penalty. The church is, and lots of groups are. But I'm talking about as a matter of American constitutional law. The death penalty has not been considered cruel and unusual punishment. Now, what can be argued as cruel and unusual punishment, and this is, again, kind of macabre, kind of graphic, but the solutions used that are injected into someone on death row who's in the electric chair or who's in the death chamber to be executed, we in many places prohibit things like shooting people, hanging people, things like that. But killing people with injections through very powerful chemicals has, if it's done appropriately, but the mixture has to be right. In other words, what could be considered cruel and unusual punishment is messing up the imposition of the death penalty at that moment when they're strapped to the gurney and those veins, their veins are being filled with those two different types of chemicals that are to kill them, to arrest the beating of the heart and to do the other things. Those chemicals don't always work. And so a person strapped to the death table in the death penalty, in the death chamber, we'll call it, where they're being executed, the mixture has got to be done correctly, because if the person's not killed, or if they are killed, I think there could be a civil suit against the state for the cruel and unusual part of it, not the killing, but the fact that they killed them in a very graphic and violent way because they didn't mix the chemicals right, or because the machine didn't work and inject at the same time in the right proportion those chemicals into the individual's body to kill it. But not the death penalty itself. The death penalty itself has not been considered cruel and unusual punishment because, you know, many states have the death penalty now. So that is where we will leave it for tonight. I think we're right at 7. Let me see if there's anything else I want to tell you. Oh, one last thing about the Eighth Amendment. It's the cruel and unusual part of it has now, as I said, been broadened to other things, including prison conditions. an inmate, a prisoner can file a petition themselves from prison, challenging whether or not a cell or a prison is extremely unsanitary, if it's overcrowded, if the inmates have insufficient medical care, if there's a deliberate failure, for example, by a warden or prison officials to protect inmates from one another. I mean, as you know, inmates kill one another all the time in prison. So the Eighth Amendment can be used to file suit in federal court from prison by a prisoner on grounds of unsanitary cells, terrible health care, medical care, a deliberate failure by officials to keep them from injuring or harming or killing one another. All those claims can arise also under the Eighth Amendment. So it's now past the original thinking, as I said, of what cruel and unusual punishment was, like hanging or stabbing someone to death or strapping them to the gurney. It's now much broader than that. So let me see if there's any questions, guys. That is the end of the lecture. Let's see, here's one. That's a question I always get. Thank you, from Shreveport. How can the death penalty not be considered cruel and unusual punishment? Well, that's exactly right. That's the point I tried to make a minute ago. It's just that the U.S. Supreme Court has said states can make that determination themselves. You know, some states allow the death penalty, some states don't. That's a huge, and I'm telling you, don't think that criminals don't think about things like that, about whether or not I'm going to commit a capital crime in a state that has the death penalty and one that does not have the death penalty. Because, for example, in Louisiana, we do the death penalty. You know, other states, and again, some states stopped all that for a while because they couldn't get the mixture correct when someone's being executed by lethal injection. And so they all got stopped for a while, or a bunch of them got stopped for a while. But once they work out that lethal potion, that lethal concoction of chemicals to efficiently kill someone who's been convicted of a capital crime, the Supreme Court has not said that the act of killing itself is cruel and unusual. The execution itself is cruel and unusual. They have allowed executions to go forward. But as I said, they got to be done to the extent you could say in a sane, not cruel and unusual way, meaning you got to get the concoction right. If it's an electric chair, the electric chair has got to jolt correctly and kill the individual quickly. I know that, again, is very graphic, but I know it's hard to believe, but the death penalty itself is not considered cruel and unusual punishment. And depending on your view of the death penalty, you would either agree or disagree with that. But that's the only question I see. The Eighth Amendment's very important. Like all of them, they're all very important. But what we have finished here from about really the Fourth Amendment, unreasonable searches and seizures, clear up to the Eighth now. And I'm not saying it's all of them, but that's a powerful set of amendments in our Constitution protecting our rights when we're charged with crimes. And what has to be done to prosecute us, to incarcerate us, and certainly to impose the death penalty. So it's a very important part, and that is the most well-known, most frequently thought of parts of the Eighth Amendment. And that was a good question. And with that, I will sign off, but we will go on to the Ninth Amendment next time. The Ninth Amendment is it's a little more conceptually abstract, but it's very important. But we're kind of wrapping up the criminal aspects of the U.S. Constitution with the Eighth. We're moving into the Ninth and then the mighty 10th. So I will see you in 2 weeks, and thanks for being here.